He recalled his order.
27/10/2017
Yes,
is recalled.
he recalled his order.
After that,
He again goes, and he again. So whoever goes, he recalls.
Okay. Recall is in his. At the time of recall, he was heard.
No.
So and then he went, you were not heard.
So my suggestion to the
none of you were heard.
So let both of us be heard.
According to you, none of you were heard.
Yes.
When these three orders were passed.
That's right.
The other side was not
heard.
Okay. What is the finding given by the learned single judge?
Ultimately, if there are two wrongs, it would not lead to one right. No, kindly see the learned single judge's observation. The order starts from page G3.
What is the reasoning?
Yes, the reasoning start from page G9. Sorry, G21, paragraph 7. May I read? Para 7. Having heard the learned advocate for respective parties and having considered the facts of the case pleaded by petitioner as well as averments made in affidavit in reply filed on behalf of respondent number 4, it is not in dispute that father of petitioner so-and-so received land bearing survey number 97 Paiki 1 at measuring 15 acres and 29 guthas, whereas respondent number 4 received land bearing survey number 97 Paiki 2 at measuring 15 acres and 28 guthas as per revenue records on account of family partition. It is not in dispute that father of petitioner received land survey number 97 and new survey so-and-so at measuring so-and-so. And petitioner...
Just a minute.
I'm sorry.
He just give this chart to understand, like, can you see? These 2 pages, so it would be readily available.
Natural justice argument is not dealt with, those specific.
There was a family partition.
Yes.
That was prior to promulgation.
Yes.
But then after promulgation.
Promulgation would not change the area of the land.
No, my case is.
In promulgation, this family partition has to give an effect too.
No, my case is at the time of promulgation, this land specifically was given to me by a further family arrangement.
How?
There was a further family arrangement.
Family settlement.
It is there in the. Because of that, the promulgation record was so made.
See, no, sorry. The partition was a family partition.
Yes.
Your shares were decided. The area was aligned. There was a promulgation. Promulgation is only correction of revenue record settlement.
Correct.
But during promulgation, there is no other settlement.
No, but a measurement was made by DIL.
So there is a mistake of measurement then.
No, it is not. Because I was actually in possession of this land. I was cultivating. Because
you cannot be in possession of the land as against the family settlement.
No, there can be a further family settlement.
Where is that?
So that is.
Your case is not based on any other family settlement.
No, my case is that this additional land was given to me for cultivation by them during at the time when
they may take it back.
But then
you have no right to.
But then the records. I am in possession of this land.
Once there is
but kindly consider.
Once there is a family settlement, it has to be given effect to.
That was
no
given.
Court can say anything beyond the family settlement.
So that was given effect to. That was much prior to promulgation.
Nothing is done in this order. In this order of superintendent of land records,
yes.
Only that family partition is given effect to. Whatever mistakes are there, they are corrected.
But for correction of mistakes.
There is no other family settlement during promulgation.
So my respectful.
Had your case been that there was another family settlement arrived between the parties?
Yes.
During promulgation,
yes.
You may be right, but that is not so.
No, kindly see. That is precisely what I have stated in my application before the.
There has to be an order then.
That order
there has to be a document of family settlement, a written family settlement. There cannot be any oral settlement.
It can be an oral family settlement.
No, during promulgation it cannot be. During promulgation,
parties are in respective possession
during promulgation, once the authority has to pass an order, there has to be a written settlement. It cannot be an oral settlement.
But no, there is no prohibition. There is no prohibition. I'll read para 7. I'll read para 7 and formulate my submission.
So it falls within the category of mistake. And it was corrected by taking aid of the government resolution.
It was probably not a mistake, because
it was a mistake.
So there are 3 submissions which I am making. So the first submission is that the impugn order of the Superintendent of Land Records was an ex parte order. It was in violation of principles of natural justice. Even if it is treated to be a mistake, since if a mistake has to be corrected, opportunity of hearing has to be given to a person who is adversely affected. By this order, No, my revenue records are closed. And therefore, because this order could not have been passed without hearing me. That is the first submission. Well, the second submission is,
Now you file an appeal under section 1203. Go and file appeal. Establish that there was a family partition during promulgation and whatever entries are during
Yes.
promulgation, they are correct.
I can file, but this order will have to be set aside and
No.
otherwise I can't
Yes,
file.
see, it is still the order of the superintendent of land record,
No, this order
which
learned
is
single judge.
appealable before the collector.
But I don't mind, my lord.
See, all of three orders, all the orders are appealable before the collector. You file appeal.
Yes.
Now this is your turn to file appeal.
I have no
Not
objection.
their one.
This order, the learned single judge's order will have to be set aside.
No.
Because the learned single judge has gone into merits.
So we will say that if you file appeal, any observation made by the learned single judge will not.
But it is not an observation. Learned single judge has given a finding.
We will also say that findings given by the learned single judge will not come in your way.
But no, the government is saying there is no appeal maintainable.
No,
That
they
is
are not saying this.
that
They
is
are
not-
saying that for correction, the government resolution says that lot of hassle is there in filing appeal. The farmers have to spend money. They have to engage lawyers. So give them some respite to seek for correction of revenue records. This avenue is provided.
Yes.
It is not substitution of section 203.
Because appeal after this order may not have any.
It is maintainable.
It may not have any meaning. May not.
Against any order. Section 120.
No, but after the learned single judge's observations and findings,
I'm not saying that you file appeal against the order of the learned single judge.
I understand. No, I'm saying if this order remains.
Once we say that all factual dispute and your assertion that there was some compromise which was entered during
It is in my
promulgation,
favor.
you
So
can
we
judge
have not given correct
establish that.
settlement by him in my favor. I may just give a little fact, my lord.
No, so no, my
If this is your argument
Yes.
that there was some settlement which modified